with Monday's ruling by Judge Sulet Potterill of the North Gauteng High Court in the case brought by the Minister of Public Enterprises, Pravin Gordhan. She's also said that she's considering legal recourse and remedies available to her, including sending the matter to the Judicial Services Commission for consideration. Let's now welcome on our set Bulelwa Mabasa. She's a constitutional lawyer and also working with the land reform panel. But let's start with this conversation. There's so many conversations. Welcome and thanks for making the time this morning.
It's a pleasure.
There are quite a few conversations going on nationally at the moment about the Constitution, about legal processes. As you can see on television, half the time we're at the courts looking at outcomes and outcomes that are being challenged. What, from a legal point of view, are these conversations valid?
Look, I think firstly, to answer the question, we need to realize that we've got three arms of government. The judiciary being one of them, we've got the executive as well. And so what we're seeing here is a kind of a shift to a more judiciary-centric approach, where even...
where mostly it's been the executive side that has emphasis.
Exactly, and maybe that is a signal of a failure of one arm of government, where one arm of government is weaker. There seems to be more and more reliance on the judiciary to solve even issues that other people may argue should not be resolved by the courts. So we are at that precipice in our country where we're seeing more and more entering of the judiciary, even in matters that should be political issues.
And in that gist then, the judicial side is not really used to being questioned. How is the legal fraternity handling this new way, these new conversations and these challenges to the work that they do? The public protector is saying, I'm going to take Judge Potterill to the Judicial Services Council to see if her decision is correct.
Look, I think that's unfortunate. I think it's important in a constitutional democracy that we have an independent judiciary. And our judicial system is such that it has inherent checks and balances with lower courts and decisions being able to be appealed to higher courts all the way to the constitutional court. So the premise is not that judges are perfect or judges are not subjective, but inherent in the system are those checks and balances where a party is able to take a decision for review or for appeal. But to say that we have a judiciary that is not impartial, I think that's treading into dangerous territory for public perception, and I think even beyond our shores. We've always had a reputation of having a robust judiciary, a system that works, a judiciary that is independent. And so I think we need to steer clear from parties who are not happy with court judgments, to steer clear from attacking the body of the judiciary, but rather stick with the issues that they're unhappy with in terms of the merits of the case. And I think that's where the difference is. There's a difference between a party saying they don't agree with how a judge arrived at a decision, but I think it's quite a different thing to say that the judiciary is somewhat tainted for lack of independence. I think that is the way we should draw the line.
The biggest sentiment in terms of the disagreements has been how decisions are racially based in terms of people who can afford access to the law and those who can't. What's your sense there?
Look, I think we've, for example, if with the EFF challenge saying that there's something untoward that Judge Potterill says. I mean, we've got so many other cases in our jurisprudence where the EFF has succeeded in the very same courts and within the same judiciary. And so I think it's important that when judges make decisions, they do so based on existing legal precedents and the facts of the case that sits before them. It's not to say that judges are, they always have Solomonic wisdom and that they are not infallible. But within the system are checks and balances where a party is able to appeal a case to a higher court, and decisions by judges get overturned all the time. So that's not what should worry us. What should worry us is when decisions that emanate from the court cannot be supported by any precedents. And I think this is where people have muddied the waters, is that decisions that are made by courts have to be supported by existing legal precedents.
And then comes the question, how far can you go in terms of appealing, going back to the public protector's assertion that she's going to be weighing up her avenues that are available to her for recourse? How far can you go?
Look, the decision that was made, I think it was yesterday or 2 days ago, that was an interim order allowing the review process to take place before, it was an interim order allowing the review process to take place. The question has been, can the public protector appeal an interim order? And that's a very legally technical argument. And there are judicial decisions pro and against. In my view, it would be very uncharacteristic for the public protector to take that route, because ultimately the issues on the merits of the case have to be ventilated in the review itself. So I do not necessarily see the utility of challenging the interim order itself, because the issues are still yet to be determined in a review application.
So you're in disagreement?
I am.
There's this conversation again about how much Twitter has almost become like a courtroom. Somebody was saying yesterday, I think, where have all these lawyers been that are suddenly surfacing on Twitter? But a legitimate lawyer, the chairperson of the EFF this morning, was saying there are legal avenues and that allow her to continue.
As I've said, with each and every matter, there are always
pros and cons,
and there's always decisions that parties are able to rely on to pursue a course that they are after. And so that's nothing, that's nothing uncommon in our law. We've dealt with cases where we've had interim decisions that were taken and other parties were able to appeal those. But each case, we must remember, must be based on its own, based on its own merits. There isn't a blanket system that applies for each and every case.
I'm going to take you back to what you said at the beginning of our conversation, because I think it's very important. You were saying that the reason why there's so much emphasis on the judicial system is because there's an arm of government that is failing. What are those failures?
Look, we've seen the failures that have ranged. I mean, we've got constitutional law decisions that we can quote. We've seen with the SASA decision with the grants, that was one example where an arm of government did not act as it should have. Even with the
things that could have been decided in Parliament.
Absolutely. And so we're seeing more and more, even amongst the legal scholars, there's one argument that says our courts are now entering into a place where they are in the job of governing, which is not why the judiciary is there. And you have another school of thought that says, well, the courts must have that wider discretionary power to assist in the development of the executive doing its work. So there is that
So is it a good thing that one arm is able to step up when the other arm
Look, I don't think that was not what our constitution envisaged.
Okay.
Our constitution envisaged that all the different arms of government would be efficient and be doing what they were constitutionally obliged to do. And so I think this is a signal of a crisis in the states, whether we are sitting with a capable state and whether we are sitting with parliament that's doing its job properly, or the executive that is also undertaking the executive functions and powers as they need to in terms of the constitution.
Your other work is being involved in the land reform process. The panel, the presidential panel, bringing out a report at the weekend, and some of the contributors disagreeing in terms of some parts of the report. Well, take us through that process. What was it like?
Look, the process was vigorous. We were appointed in September 2018. We had 9 months to issue a report, but we understood very well that there was already evidence-based approaches and knowledge that existed, but we needed to take the conversation further. Our terms of reference were there to assist the president and his cabinet to come up with a unified new perspective on land reform. I think it's been, we can all agree that 25 years ago it's been one of the biggest failures. And so this process that we were undertaking was so that we can assist the president and the cabinet in firstly identifying the problems, but also coming up with recommendations that can take the discussion forward.
what happens to the disagreements in terms of even the participants in the panel?
Yes.
You can imagine how much that disagreement flows over into society.
Look, I think that was also expected, because within our terms of reference, there was provision to be made that where we cannot reach a unanimous decision, that we will state what those areas of disagreements. I think the public perception around the disagreement is a little overstated. And I say this because even with the alternative reports that exist within the panel, the overwhelming majority agrees with the current recommendations. And the area of disagreement is largely based on the fact that the two members of the panel do not agree at all with expropriation without compensation. And what the panel has said is there are circumstances that warrant expropriation without compensation. So I wouldn't say that that level of disagreement is one that should collapse the report or the recommendations. In fact, I would say the opposite. That most, if not all of the recommendations, there was unanimity, except on those issues around expropriation without compensation, and also issues around expropriation without compensation for labor tenants and farm dwellers.
Bulelwa, as it happens with television, we always have time constraints, but thank you so much for your thoughts. Very valuable. We hope you can visit us another time.
I will,
to
certainly
come and carry on the conversations. Bulelwa Mabasa is a constitutional lawyer and specializing in land reform. Let's take a